Hi, this is Adam Stofsky with Briefly, and I'm here with Jordan Gustafson talking about family law and family law issues. Today, we're going to talk about a really challenging, probably maybe the most challenging issue in divorce and family law, which is child custody and visitation. So, Jordan, can you just explain what it means? When we say custody and visitation, what do we mean?
Yes. So custody and visitation is the portion of the family law court where the court's able to make orders that relate to the children of the case. Child custody is split up into two categories, one being legal custody, which is who gets to make decisions on healthcare, education, and other issues that affect the welfare of the child. And then the physical custody is who the child spends the most time with. And then the visitation portion of that is kind of a subsection of the physical custody that sets the exact schedule of when the children will visit with each parent.
So you can have legal custody. Can you have legal custody and not have physical custody, or vice versa?
Yes, it's very, maybe not very common, but it's common for one parent to have sole legal custody. So it can either be sole or it can be joint. And it's not uncommon for one parent to have sole legal custody, meaning that they get to decide where the child's going to go to school, who their doctors are, what treatment they'll receive, and still share, fairly equal time with the other parent. That may be because the other parent has interfered with decision making in the past, or maybe doesn't respond to messages and makes it difficult for the child to get the care that they need. So there could be a variety of reasons why a parent may not have legal custody, but they still have a fair amount of physical custody and visitation with the child.
Okay, so we have legal custody, physical custody, and then visitation, which is for parents that might not have physical custody but want to be able to see their children. Basically, is that right?
Yes, and the visitation can be ordered even if the parties have joint legal, joint physical. There will still almost always be visitation orders just to determine what that schedule should look like. And the reverse is also true, where a parent may have no legal or physical custody, but they're still granted visitation.
Well, that's
So there's a lot of different scenarios where they all kind of intermix.
so. Who needs a custody and visitation order?
We recommend it in most cases just to make sure that everything is set forth and each party knows what their rights and visitation schedule would be. But it could be in any case where the parents are not living together and kind of need those orders to determine essentially how things are going to play out moving forward, who gets to make those decisions, and when are they going to be able to see the children.
So basically, in any situation where there's a child and the parents aren't living together, whether they were never married or never together, or there's been a divorce, in all those situations, you need to have this order.
Yes, exactly.
Mm.
It's possible there are cases where the parties are working together and they're in agreement as to all issues and they don't seek these orders, which is perfectly fine in those cases as well. But when the disagreements start to arise, it is helpful to have it set forth in a parenting plan where there is not so much room for disagreement and each party knows kind of where they stand on everything.
So when the time comes to get this order, how do you go about doing it? How do you start the process?
Yes, that depends on if the parties were married or not. If the parties were married, the route to do that would either be through divorce, filing a petition for divorce, a petition for legal separation, or a petition for custody and support of a minor child. So if for some reason there's just a separation, but they're not ready to take that next step of actually filing for divorce, they can file a petition for support in custody. And that would allow them to just address these custody issues without actually taking steps to terminate the marriage.
R-
And if the parties weren't married, then the common route would be a petition to establish parental relationship.
So maybe that relates to my next question: is who can do this? Can any parent do this? Seek this order?
Yes. Yes. Anyone who has, oftentimes they won't have been found to be a legal parent yet, but anyone claiming to be a legal parent can file an action for custody and visitation.
Okay. So then, what's the process?
Yeah. So once the party files a petition in any of those cases that I listed before, and the other party is served with it, Then the case is ready to proceed, and the party would need to file a request for order for custody and visitation. And that's going to look the same in any of the scenarios described before. So regardless of what type of case it is, they would need to file a request for order for custody and visitation. And then generally the next step in that process would be going to what's called child custody recommending counseling, or more commonly referred to as mediation, where they would essentially try to work, see if they can come to an agreement regarding these issues prior to going to their court hearing, which would be the next step in that. They would meet in front of the judge to address what occurred in mediation.
And after that, the judge will issue an order of some kind?
Yes, at that point, the court would usually make orders for temporary custody and visitation. And the next step, if the parties still disagree, could be an evidentiary hearing, which is what people commonly see as a trial, or what you're used to seeing on TV, where the parties are presenting their evidence and their witnesses. And then at that point, after a trial, the court could make what they would call permanent custody orders.
What are the factors the court uses to determine who gets custody and what kind of custody, how it's allocated, basically?
Yes, it is very fact dependent, and each case is different, and there can be outside factors or kind of rules that come into play. But the baseline standard is the court seeking to determine what is in the best interest of the children. And they can look at a variety of factors, where the parents are living, who they have a stronger tie with. One big thing they look at is which parent is more likely to facilitate a relationship with the non-custodial parent. So if you have a parent who's, maybe being aggressive or trying to interfere, speak negatively about the other parent, the court can consider factors like that to determine how much time that parent should have with the child. So they have really broad discretion on what they're able to consider, but the end goal is determining what's in the best interest of the children.
So there's a lot of different factors, and they just have to kind of weigh them all and balance them all?
Yes, and a lot of it will come down to what evidence or what issues are brought up by the parties. They may not go through every factor in every case, but if there's, a circumstance that brought that to light, or there's been a history of, maybe conflict between the parents, or even if there's been, let's say, domestic violence, that raises a special presumption. So if one party has been found to have committed domestic violence within the prior 5 years, there's actually a presumption that they should not have legal or physical custody for those 5 years unless they present evidence to the court, essentially proving why they should be able to have physical custody. So there's a lot of different scenarios and things that can come into play in each case.
There's the existence of like substance abuse, alcoholism, drug abuse. Does that also trigger this presumption, or is it really just actual abuse of the spouse or the children?
That presumption requires a finding of domestic violence.
Got it. Okay.
All the ego hand in hand, and the court can obviously address substance abuse or alcohol issues and make orders to address that, whether that's requiring AA meetings. There's even devices for monitoring if a party's drinking. They have like facial recognition, and the party has to do it every so many hours when they're in the care of the children, or when the children are in their care. So there's a lot of things that the court is able to do if they're presented with evidence of abuse of any kind.
Interesting. Okay, so once the order is in place, sort of what happens? Does the child just go home with a custodial parent? Like what happens after that? And how does it work?
So once the court makes orders, those are the order of the court until further orders are made. So even if a party receives a judgment and receives what the court calls permanent orders, child custody is never actually permanent. It can always be modified if there's a substantial change in circumstances. So the parties go home with their orders, they go about their visitation schedule. But if something occurs, maybe someone develops a substance use issue, or they're acting erratically during drop-offs. Maybe one party wants to move or got a new job and they can't work with that schedule. If any of those things occur, the party can file another request for order to go back to court and modify things at that time. so long as there's a reasonable justification for modifying those orders.
Can you do this on your own, or do you need to have a lawyer?
Obviously, we always advise, if possible, it's best to have an attorney, but the family court system, a wide range of the cases are from self-represented litigants. So the court is used to people representing themselves, and it's definitely not uncommon to have to go through this process on your own. So yes, if possible, an attorney's, it's always great to consult with an attorney, but it can absolutely be done on your own as well.
Okay, so relevant to that, how can Inland County's legal services help?
Yes, our family law team, we assist with the initial petitions to kind of get that case open. We often assist with the request for orders. Sometimes we do offer representation. Sometimes it's just helping with prepare the documents and providing advice and counsel and helping people prep for their hearings, or, even if the parties reach an agreement, we've helped draft judgments. So we kind of have a wide area of ways that we're able to assist in family law.
Okay, great. All right, Jordan, thank you so much.
Thank you, Adam.